Okay, so the purpose of today's video is just an overview of the key components of precedent. And these are all the different components that you would check off to make sure that you knew this topic. And sometimes this topic can be considered one of the most difficult ones, but I think once you are aware of all the different chunks and you know something about each of those, using the examiner's reports, because this is what I say to my students, I say always turn the light on, look for the question, look for the examiner's report, look at what the key strengths were, the weaknesses that, students who had answered that question previously in the exam had done well, had not done so well, and then make sure that you focus on all the strengths. So to begin with, obviously a good definition of precedent, it's where a case comes up before the court, it's not been decided before. Once they've got a decision in it, that is your precedent. The ratio decidendi, remember, is your reason for the decision. Any obiter dictas are other things said, by the way. Once they've decided that case, any future similar cases that come up are decided according to that original decision that was made. So there's no repetition. Judges don't feel that they have to keep on deciding or making the decision in cases again over and over and over again. It's been decided once, and that should be fine. So remember stare decisis, let the decision stand. Make sure you know your hierarchy, because the hierarchy is really important for judicial precedent, because in order for it to work, you need to know how each court handles decisions that are made. So what is a court hierarchy? It's a ranking in order. The lower courts deal with the less serious matters, and the higher courts hear the most serious matters. And what you need to know, we're not in Europe now, but if we look from the Supreme Court downwards, so the Supreme Court has the Practice Statement. It's our most senior court in the land, and it can depart from its previous decisions wherever it appears right to do so since the Practice Statement 1966. Now, they rarely do it. They're quite cautious. If you watch my video on the advantages and disadvantages of precedent, I do cover some key cases that were decided in the Supreme Court, or it was called the House of Lords then, where they did depart from previous decisions, and the reasons why they departed from them were things like changes in society and humane reasons as well, and also bad, outdated law, like for example in R&R with a marital rape case, where there was an exemption previously for married men, but there is no longer that exemption. So the Practice Statement means that the Supreme Court can depart from previous decisions. So it's not so rigidly bound. And then below that, you've got your Court of Appeal. It's bound by its own decisions, bound by the Supreme Court, but it does have the young exception. So make sure you know those three young exceptions where it can also depart from its previous decisions. And remember, it's things like there were two previous Court of Appeal decisions, they conflict, or there's a previous Court of Appeal decision and a Supreme Court decision, and they both conflict, but because the Supreme Court is above them, then they would have to follow the Supreme Court decision and abandon their own. And the third is where a decision was made per incuriam, i.e. was made in error. The High Court is bound by the courts above it, binds the courts below it, including its own divisional courts, but it's not so, it doesn't follow precedent as strictly. And then the lower courts, like the Crown Court, County Court and the Magistrates Court, they're not bound by their own decisions, and they don't bind each other. And so many cases travel through those courts that you wouldn't expect them to make precedent decisions, but they are bound by the higher courts. So it's important that you know your court hierarchy. If you had a question that was about, what are the key features of precedent, you want to be covering things like some information about law reporting, because you couldn't have a effective functioning judicial precedent system if you didn't have law reporting. And since 1865, we've now got accurate law reports, and before then they were quite gossipy. How people do, somebody's got one point of view, somebody's got another, and some irrelevant things were discussed. But since 1865, our law reporting has become more accurate, and there are so many places where you can find law reports, and a vast amount of cases online. So you want to say something about law reporting, you want to say something about the court hierarchy, you want to say, you begin the whole thing obviously with your introduction to judicial precedent and your definition of what it is. Ratio decidendi, the reason for the decision is really important. Obiter dicta, your hypothetical examples, other things said by the way. So if you pull these things together, you are writing about the key features of precedent. And you do have to pull all of those together, and you've got to be quite savvy and smart, because you've got to say something about each of those within the time frame you've got, and you've got to consider how many marks you have. And then you could have a question on just ratio decidendi and law reporting, or obiter dicta and law reporting. Again, enough information on each of those areas. I'm going to have just a lineup, a checklist at the end of this video, so just check those and tick off the things as you study them. And remember, can't say it enough, back up everything with enough cases that show your understanding and your knowledge. Okay, thanks for watching, and I will post further videos to help you. Happy learning, and take care, and I will see you next time.